C'est peut-être trop tôt pour enregistrer si on attend encore 5 minutes.
Non, parce que j'ai peur d'oublier.
D'accord. By the way, I welcome the panelists, Adrien, Mats, Halak, Abba, is he with us?
Coming.
Coming, okay. Good afternoon, Azel. I just forget your name.
Hello, good afternoon.
Good afternoon, and thank you for joining us.
Thank you.
Abdeslam, bonjour. Peut-être tu
Bonjour.
peux couper ton micro si jamais tu fais l'interprétation.
مساء الخير.
Oui, bonjour.
هل أنت من سيقوم بعملية الترجمة أو الترجمة؟ أهلا، مساء الخير.
Au Meima, tu peux dire aux interprètes de couper le micro, sinon on va entendre l'intervenant et l'interprétation. Si vous êtes prête au Meima, on peut commencer.
Je ne sais pas qu'est-ce qui se passe, il est en train de se répéter les sons, je ne sais pas pourquoi. Je ne sais pas qu'est-ce qui se passe, il est en train de se répéter les sons, je ne sais pas pourquoi. Je ne sais pas qu'est-ce qui se passe, il est en train de se répéter les sons, je ne sais pas pourquoi. Je ne sais pas qu'est-ce qui se passe, il est en train de se répéter les sons, je ne sais pas pourquoi.
Coupe ton micro, déjà.
C'est bon, je crois que c'est bien maintenant.
D'accord, on peut commencer alors.
Vous m'écoutez en français?
Oui, mais il faudrait que seulement ceux qui mettent l'interprétation.
C'est bon maintenant, Jean-Franco, c'est bon.
Oui, tout est bon?
Oui.
OK. Then I welcome all of you for this webinar conference, high-level conference on the effectiveness of the Universal Periodic Review in occupied territories. First of all, a technical information. We have interpretation in 4 languages: English, French, Spanish, and Arabic. Donc, il y a l'interprétation en français, anglais, espagnol et arabe. Tenemos interpretación en francés, inglés y espagnol y árabe. Oumaima, je te laisse dire ça en arabe.
السلام عليكم ورحمة الله. عندنا الترجمة باللغة العربية، الإسبانية، الفرنسية والإنجليزية. شكرا لكم جميعا للحضور.
And with this announcement, I think we will start with a video message from the Ambassador Nkosi, permanent representative of South Africa at the UN in Geneva.
Excellencies, distinguished panelists, ladies and gentlemen, on behalf of the members of the Geneva Support Group for Western Sahara, it is my honor and privilege as chairperson of the group to welcome you all to this high-level webinar conference on the theme, the effectiveness of the Your Excellencies, distinguished panelists, ladies and gentlemen. The subject of today's conference of the members of the Geneva Support Group for Western Sahara, occupation of territory. It is my honor and privilege as chairperson of the group to welcome you all to this high-level webinar conference on the theme, the effectiveness of the Universal Periodic Review in occupied territories. The subject of today's conference is pertinent, given the continued occupation of territories of Palestine and Western Sahara. It is of specific relevance to the mandate of the Human Rights Council as it concerns a situation in which victims do not have procedures for internal remedies that can ensure the respect of their rights. In both cases, the judicial system is in the hands of the occupying power, and therefore nobody can expect that the systematic violations of the occupied people's rights are duly examined.
Sorry, a little bit problem, technical mission. Sorry, a little bit.
Your Excellencies, distinguished panelists, ladies and gentlemen, on behalf of the members of the Geneva Support Group for Western Sahara, it is my honor and privilege as chairperson of the group to welcome you all to this high-level webinar conference on the theme, the effectiveness of the Universal Periodic Review in occupied territories. The subject of today's conference is pertinent, given the continued occupation of territories of Palestine and Western Sahara. It is of specific relevance to the mandate of the Human Rights Council as it concerns a situation in which victims do not have procedures for internal remedies that can ensure the respect of their rights. In both cases, the judicial system is in the hands of the occupying power, and therefore nobody can expect that the systematic violations of the occupied people's rights are duly examined and punished. We chose to focus this conference on the cases of the occupied Palestinian territory and of the non-self-governing territory of Western Sahara, because these are by far the oldest cases of illegal military occupation. Situations that by definition should be inscribed in the Human Rights Council's agenda. And indeed, this is the case for the occupied Palestinian territory, but unfortunately not so for Western Sahara. Therefore, the Universal Periodic Review is the right place for the international community to analyze the peculiar situation of the Sahrawis, to whom 30 years ago, the United Nations and the then Organization for African Unity promised the holding of a free referendum of self-determination and independence. However, the Sahrawis are still suffering the
ويعود بتنظيم استفتاء حر ونزيه.
launched.
في تقرير مصيري والاستقلال لكن برغم أنه
What we
يعانون
can
من
draw from the experience gained in the previous 3 cycles of the Universal Periodic Review is that Israel rejects all recommendations related to the human rights violations in the occupied Palestinian territory. While very few states make observations
ما يمكن استخلاصه من الدورات الثلاث انتهاكها الإنسان في
in the occupied Western Sahara. The unfortunate resumption of the armed conflict with the Polisario Front in November 2020 may attract the attention of several members of the international community and thus provide an opportunity for the Human Rights Council to contribute to the decolonization process of this part of Africa. We will indeed use this opportunity to take advantage of the valuable contributions from the panelists in order to analyze in detail the failures of the previous 3 UPR cycles on this particular issue, in order to be able to suggest ways and means for a more effective periodic review process in territories under occupation. The government and people of South Africa are determined to support the Palestinian and the Sahrawi people. And indeed, we stand firm for the equal application of international law everywhere. Finally, it is my pleasure to now hand over the floor to the moderator of the conference, Mr. Fattorini. And let me take this opportunity to wish you all an instructive and fruitful session. I thank you for your kind attention.
I thank you, Ambassador Nkosi, for his introductory remarks. Unfortunately, he cannot be with us due to other engagement in the framework of the ongoing Human Rights Council. So the Universal Periodic Review has been designated as a cooperative mechanism based on interactive dialogue. With the experience of the 3 cycles of UPR behind us, it is indeed interesting to assess the effectiveness of these mechanisms in 2 territories that the General Assembly and the International Court of Justice consider as territories under occupation, Palestine and Western Sahara. If both territories are inhabited by Arab peoples, they don't enjoy the same academic and public interest, in the same way that they do not have the same support from other Arab countries. While the Palestinian occupation calls for a united Arab cause, the Moroccan propaganda promotes the idea of a separatist movement that attempts to Arab unity, disregarding the divisions that he himself is causing within African unity. Of course, the 2 territories have a different historical, sociopolitical, and geopolitical background, but their common point is that their respective former colonial powers have been far too hesitant in implementing UN resolutions and achieve a peaceful decolonization process. Throughout the years, thousands of Palestinians and Sahrawis civilians have been killed, disappeared, or had to flee and seek refuge in neighboring countries. Throughout the years, the 2 occupying powers have each built a separation wall that constitutes a crime against humanity. Despite evidence of systematic and serious violations of international humanitarian law and human rights, the occupying powers and their leaders enjoy total impunity. Today, both occupying powers, Israel and the Kingdom of Morocco, enjoy strong support from Western powers in terms of financial and commercial facilities, as well as military and political assistance, which reinforce and perpetuate their respective illegal occupation. It is hardly surprising that the European Union has developed its strongest trade relations with these 2 occupying powers than with any other state bordering the Union, and that it continues to do so despite the adoption by its
Après l'adoption de la part des États membres en décembre
facilidades financieras, comerciales, así como asistencia militar y política que refuerzan y efectúan sus respectivas ocupaciones ilegales. Sorprende que la Unión Europea haya desarrollado
Même si on peut éviter d'entendre tous les interprètes.
comerciales con estas dos potencias ocupantes más que cualquier otro estado.
مترجمين من فضلكم سكتوا شوي مترجمين سكتوا من فضلكم.
So it is hardly surprising that the European Union has developed the strongest trade relations with these two occupying powers than with any other states bordering the Union, and that it continues to do so despite the adoption by its member states in December 2020 of a very severe global human rights sanctions regime. The United States, for its part, has injected and continues to inject tens of billions of dollars to support militarily the two illegal occupations, not in the name of protecting the right of the local population, as it says on other occasions, but supposedly to protect its fundamental interests. It is in the light of these fundamental contradictions that the panelists will analyze the effectiveness of the Universal Periodic Review in the occupied territories, the quantity and the content of the proposed recommendations, and the willingness of the occupying powers to implement them. Without further ado, I give the floor now to the first panelist, Mr. Abba El Hassan, President of the Sahrawi National Commission for Human Rights.
Je donne la parole à M. Abba El Hassan, président de la Commission nationale sahraoui des droits de l'homme.
Abba, tu as le micro.
Bonjour, bonjour Gianfranco. Vous m'entendez? Allô?
Oui, c'est à toi, Abba. Tu peux, oui, tu peux y aller.
Ok, merci beaucoup, cher ami Gianfranco.
شكرا جزيلا صديقي مراتوني.
Excellences, Mesdames, Messieurs, je tiens avant tout à remercier les organisateurs de cette réunion de me donner l'opportunité de m'adresser à vous en marge de la 50e édition du Conseil des droits de l'homme.
Abba, attends un instant, parce qu'on entend plus les interprètes que toi. Maïma, on peut régler le problème?
Normalement, il est réglé. On va essayer maintenant.
OK. Parle plus fort, Abba, parce qu'on n'entend pas très bien.
D'accord.
Tu peux y aller.
Bonjour, ça va maintenant?
Très bien, vas-y.
OK, Excellences, Mesdames, Messieurs, je tiens avant tout à remercier les organisateurs de cette réunion de me donner l'opportunité de m'adresser à vous en marge de la 50e édition du Conseil des droits de l'homme. Je remercie également toutes les personnalités qui participent à cette conférence.
وكذلك أشكر كل الشخصيات المشاركة في هذه الندوة والتي تبرز وتعبر عن دعمها. هناك تداخل في الصوت، هل يمكن حل هذه الإشكالية؟ الأخت أميمة.
Il y a un problème technique au niveau des interprètes.
Allez, maintenant, on va voir maintenant si ça marche. Sinon, on va annuler l'interprétation. Maintenant, on y va.
OK.
Vas-y, Abba.
OK, en effet, dès lors qu'on considère la situation de les territoires illégalement occupés par une puissance étrangère depuis des décennies, on ne peut que constater l'absence de l'état des droits et la violation systématique des droits internationaux notamment le droit international humanitaire et des droits humains. Il y a tout d'abord un aspect qu'il faut clarifier. C'est celui de l'égalité de l'occupation du Sahara occidental par le Maroc. Il ne s'agit pas là de considérations politiques, mais bien de concepts légaux et juridiques. L'occupation du Sahara occidental de la part du Royaume du Maroc doit être considérée illégale, car elle viole 4 principes fondamentaux. En premier lieu, en droit international, il est reconnu qu'une puissance occupante ne peut pas conquérir, annexer ou acquérir un quelconque titre juridique au souverain sur une partie quelconque des territoires sous son occupation. Je dois rappeler ici qu'en 1975, déjà avant l'invasion du Sahara occidental par le Maroc, la Cour internationale de justice avait établi que les éléments et renseignements portés à sa connaissance n'établissent l'existence d'aucun lien de souveraineté territoriale entre le territoire du Sahara occidental et le Royaume du Maroc. Le deuxième principe fondamental en droit international veut qu'une occupation soit temporaire et ne peut être ni permanente ni indéfinie. La persistance posture du Royaume du Maroc dans les négociations ainsi que dans les discours récurrents du roi du Maroc Mohamed VI, ainsi que sa volonté de faire reconnaître par d'autres États la marocanité entre guillemets du Sahara occidental montre que le Royaume du Maroc n'a aucune intention de mettre fin à son occupation. Le troisième principe du droit international veut que pendant l'occupation, l'occupant agisse dans le meilleur intérêt du peuple sous occupation. Le pillage systématique des ressources naturelles du Sahara occidental par le Royaume du Maroc, avec la complicité de plusieurs États, y compris l'Union européenne et de ses États membres, ainsi que les violations graves et persistantes des conventions de Genève et le caractère systématique des violations des droits de l'homme, y compris des droits de développement commises par la puissance occupante, illustre que les autorités marocaines n'ont jamais pris en compte les intérêts des peuples sous occupation. Au contraire, les activités économiques développées au Sahara occidental occupé, y compris par les campagnes détenues par la famille royale elle-même, servent d'abord à financer l'occupation militaire des territoires et gonfler les comptes bancaires de Mohamed VI et sa famille. Le quatrième et dernier principe affirme que l'occupant doit administrer le territoire occupé de bonne foi. En effet, le principe de bonne foi est une règle cardinale de l'interprétation des traités. La volonté farouche d'appliquer des traités commerciaux avec l'Union européenne au territoire occupé du Sahara occidental, ainsi que les actions entreprises par le Maroc contre la République arabe sahraoui démocratique dans le cadre de l'Union africaine remettent en question la bonne foi dans l'interprétation des traités internationaux, y compris l'acte constitutif de l'Union africaine par le Maroc dans le cas du Sahara occidental. Une fois établie l'égalité de l'occupation des territoires du Sahara occidental de la part du Maroc, il faut considérer quelles sont les conséquences sur la jouissance des droits fondamentaux du peuple sahraoui. Une fois établie de l'occupation des territoires sahraouis de la part du Maroc, il faut considérer quelles sont les conséquences sur la jouissance des droits fondamentaux des Sahraouis. Avant d'approfondir cette question, je souhaite rappeler que l'occupation illégale du Sahara occidental par le Maroc a été la source et continue d'être la source également des violations systématiques et graves des normes du droit international humanitaire. Je fais référence ici en particulier aux violations des articles 31 et 32 de la 4e Convention de Genève, interdisant la correction, les châtiments corporels, la torture et les traitements dégradants et inhumains, et aussi aux violations de l'article 33 qui interdit les sanctions collectives, l'intimidation, le pillage et les représailles, aux violations de l'article 49, interdisant les déportations, le transfert de populations civiles du territoire occupé à celui de la puissance occupante et vice-versa, aux violations de l'article 53, qui interdit la destruction des biens, des meubles, des appartements appartenant individuellement ou collectivement à des personnes privées. Et enfin, je me réfère aux violences de l'article 76 portant sur le traitement des détenus. Certaines de ces violations peuvent constituer des crimes de guerre et ou des crimes contre l'humanité par lesquels un jour une instance internationale indépendante devrait en évaluer la portée et les responsabilités. Mesdames, Messieurs, il ne faut pas non plus oublier l'usage d'armes interdites dès les années 70 et 80, telles que les bombes au phosphore, ou l'usage depuis la reprise du conflit en novembre 2020. Des drones qui ont 27 attaques ont frappé des civils sahraouis et du bétail à l'est du mur des militaires de défense de séparation marocains, causant la mort des Sahraouis, ainsi que des citoyens algériens et mauritaniens qui traversaient le territoire du Sahara occidental pour faire du commerce. Pour revenir à la question des violations des droits fondamentaux du peuple sahraoui, qui devrait faire l'objet de l'attention de chacun à l'occasion de l'examen périodique du Royaume du Maroc au mois de novembre prochain. Je ne vais pas ici énumérer les dizaines et centaines de violations commises quotidiennement à l'encontre de la population civile sahraoui, car ce n'est pas le lieu. Mais je me limiterai à mettre en lumière des violations des droits humains touchant des domaines essentiels de la vie du peuple sahraoui liés à l'occupation illégale des territoires. Tout d'abord, bien entendu, la violation des droits inaliénables à l'autodétermination et à l'indépendance, tels que consacrés par la Charte des Nations Unies et les résolutions 15-14 et 26-25 de l'Assemblée générale. Oui. La mission du Haut-Commissariat aux droits de l'homme de 2006 avait souligné dans ses conclusions dans son rapport que la violation de ce droit est à la base de toutes les violations des droits humains subies par le peuple sahraoui. La violation des droits à l'autodétermination engendre la violation des droits au développement du territoire du Sahara occidental, tel que défini dans la résolution 41/128 adoptée par l'Assemblée générale de l'ONU en décembre 1986. L'Assemblée générale a déclaré que les États doivent prendre des mesures résolues pour éliminer les violations massives et flagrantes des droits de l'homme des peuples par des situations telles que le colonialisme, la domination et l'occupation étrangère, l'agression et les menaces contre l'intégrité territoriale. Je dois également souligner ici qu'en adoptant chaque année la résolution intitulée « Réalisation universelle des droits des peuples à l'autodétermination », l'Assemblée générale prie le Conseil des droits de l'homme de continuer à prêter une attention particulière aux violations des droits humains, notamment le droit à l'autodétermination qui résulte d'une intervention, d'une agression ou d'une occupation militaire étrangère. Mesdames, Messieurs, l'existence du mur de séparation militaire du Maroc ainsi que la persistante occupation militaire illégale et l'annexion d'une large partie de la République sahraoui par le Maroc nie strictement et systématiquement le droit au développement du peuple sahraoui. Afin de perpétuer l'occupation illégale dans le territoire du Sahara occidental, le Maroc maintient une très forte présence sécuritaire, militaire, afin de prévenir et réprimer toute forme de contestation de la part des Sahraouis civils, ainsi les libertés d'opinion, d'expression, de manifestation pacifique et d'association ont été simplement bannies dans les territoires occupés du Sahara occidental. Toute visite de territoire de la part d'avocats, juristes, journalistes, académiciens, personnalités politiques étrangères est interdite depuis plusieurs années. Cette interdiction vaut aussi pour le bureau du Haut Commissariat aux droits de l'homme et encore récemment pour l'envoyé personnel du secrétaire général de l'ONU, M. de Mistura. Tous ceux qui ont osé contester l'occupation militaire illégale du Sahara occidental ont dû payer à leur prix pour les engagements. Ces dernières années, tant le comité contre la torture comme le groupe de travail sur la détention arbitraire et d'autres procédures spéciales du Conseil des droits de l'homme ont manifesté leur préoccupation et constaté des violations caractérisées de normes internationales relatives aux droits humains qui les ont conduits à émettre des décisions et des recommandations appelant le Maroc à se conformer à ces normes et à assurer réparation, voire indemnisation aux victimes sahraouies. Il est notoire que les autorités marocaines refutent systématiquement les observations faites par les différents mécanismes onusiens et n'entendent aucune mettre un terme à ces pratiques violentes propres à un régime d'occupation illégale. Devant toutes ces violations des droits internationaux qui perdurent depuis des décennies et qui ont traversé la période du dégel qui a suivi la chute du mur de Berlin, comment expliquer que l'occupation militaire illégale du Sahara occidental perdure et que la communauté internationale, dans sa majorité, ne se soucie guère des sorts du peuple sahraoui, voire que les puissances occidentales, telles que les États-Unis, la France, l'Espagne et l'Union européenne dans son ensemble, appuient militairement, financièrement, économiquement et politiquement la répression des peuples sahraouis, assurant ainsi l'impunité aux acteurs et aux auteurs des crimes de guerre et des crimes contre l'humanité. Le Royaume du Maroc a développé depuis longtemps une politique de chantage à l'encontre des membres de l'Union européenne et en particulier à ses voisins des porteurs méditerranéens. Chantage à propos des flux migratoires, quitte à manipuler des centaines de migrants en créant des accidents à la frontière espagnole qui provoquent des dizaines de morts et des blessés. Chantage à propos du trafic de stupéfiants, tout en étant le plus important fournisseur de cannabis et de ses dérives pour l'Europe, ainsi que l'atteste depuis des années l'organe de contrôle des stupéfiants des Nations Unies. Chantage aussi à propos de la lutte contre le terrorisme, alors que dans la grande majorité des attentats commis sur le sol européen, on constate la présence des personnes de nationalité ou d'origine marocaine. En conclusion, Madame, Messieurs, on ne peut que regretter que les démocrates occidentaux pratiquent une politique de double standard en matière de droits humains, qu'elles ferment les yeux sur les violations systématiques des droits humains subis par le peuple sahraoui et qu'ils se rendent complices des crimes commis par le Maroc dans les territoires occupés du Sahara occidental. Cette politique décrédibilise leur discours en matière de droits humains et affaiblit le système onusien de promotion et de protection des droits humains, y compris l'examen périodique universel du Conseil des droits de l'homme. Pour que l'examen périodique universel puisse être réellement efficace, il faudrait déjà que qui prétendent être les promoteurs et les défenseurs des droits humains soient cohérents et dénoncent ouvertement les violations systématiques et les crimes commis par le partenaire et qu'il arrête à lui assurer l'impunité. Je vous remercie pour votre attention.
I don't know if all the interpreters have finished with the interpretation. Maima, is it okay?
Please ask the interpreter of Spanish to put his mic on and everything is okay. I hope everything now is going to work. Okay, so if not, we are going to cancel the interpretation.
OK. Alors, je remercie Abba El Hassan, président de la Commission nationale sahraoui pour les droits de l'homme, pour sa présentation et qui nous a donné l'occasion d'avoir un large rappel des normes du droit international concernant la situation que vit le peuple du Sahara occidental. Et maintenant, now I will give the floor to Mrs. Hazel Al-Bajeh, legal advisor and advocacy officer with the NGO Al-Haq. Hazel, you have the floor.
Thank you. Thank you for inviting Al-Haq, and thank you for organizing this important webinar. So today I will present on Israel's a review under the UPR process, just giving an overview or an outline of my intervention. I will start with focusing on the key developments since the last cycle in 2018 at the UPR process. What are the thematic issues of recommendations regarding Israel's human rights violations during the 3 cycles. I will then provide a critique of the recommendations so far during the last 3 cycles, and then propose stronger recommendations for next year or for the next cycle in 2023. I will also give a critique of the UPR process in general in the Palestinian context, given its non-confrontational approach, and also propose or provide other avenues of naming and shaming, accountability and countermeasures regarding Israel's systematic violations, human rights violations against the Palestinian people. So starting with the overview of the UPR process, it should be noted that Israel has a record or an attitude of systematic non-cooperation with the international human rights system in general. And this includes the Human Rights Council, special procedures, UN Commission of Inquiry. So Israel denies entry, for example, to commissions of inquiry, to special procedures. It doesn't renew the visa of staff of UN institutions. It also lobbies against such institutions, including accountability mechanisms such as the current, for example, the ongoing Commission of Inquiry by the Human Rights Council that was established last year. So Israel has this institutionalized effort to silence any efforts that basically want to challenge or wants to seek accountability against its violation. And this, of course, includes systematic attacks against the Human Rights Council and the UPR process. So, for example, in 2013, Israel decided to boycott the UPR process at its 2nd cycle due to perceived disproportionate bias against Israel. And this is the pretext it always gives when it is attacking these accountability mechanism against it. And this was actually set a precedent. It was the first country in the world to boycott its review at the UPR process, and the Human Rights Council at the time adopted a resolution pushing on Israel to re-engage with the UPR process, because this is a universal process. At the end, every single country in the world is being reviewed, and the pretext Israel is using specifically for this process is not justified. Now, eventually, Israel rejoined the rescheduled review in 2013. And just to give like a brief, this is in a nutshell on how Israel's attitude of attacks and non-cooperation with the international human rights system. Regarding the UPR specifically, we have seen through the last 3 cycles non-systematic non-implementation of recommendations. So for example, at the last human rights, the UPR process, there were 240 recommendations, only 70 were accepted by Israel. I can't go through all the recommendations, but I will just give some kind of case studies on some of the recommendations that Israel accepted, and how, in fact, not only it did not recommendations, but it accelerated the violations against the Palestinian people. So, for example, last cycle in 2018, there were 10 recommendations that Israel accepted regarding the need for Israel to respect and ensure human rights organizations and civil society and human rights defenders are respected and their work is not interfered with or attacked. So there were 10 recommendations that Israel accepted in this regard. Instead of implementing these recommendations, Israel accelerated its attacks against Palestinian civil society. So today, for example, I'm speaking on behalf of Al-Haq, which is the first human rights organization, not only in Palestine, but in the Middle East. So we're talking about 40 years of documentation of human rights violations on the ground and working on advocacy, accountability, and so on. What happened, bringing this example to the point of the recommendations on civil society, because Israel last year in October designated 6 leading human rights organizations, including Al-Haq, as terrorist organizations, and also issued military orders ordering their closures. Now this move basically puts the 6 organizations at risk of being closed. The staff, they are at threat of being arrested. Our assets and funding is also under threat of being confiscated. And eventually this move is to basically, it exemplifies the bigger project that Israel wants to shut down Palestinian civil society or any voice that tries to critique and challenge and expose its violations. And unfortunately, we have seen a lot of support from international community, including from states, acknowledging that this decision by Israel to designate organization as terrorist is a political move. It's an arbitrary move, it's an illegal move. But we haven't seen actions by state to push on Israel to rescind the designation. So unfortunately, just last month, Israeli occupying forces raided the 6 offices that were designated last year as terrorist organization. They confiscated equipment, equipment and file, and issued another military orders that says that we should close our offices, and they also started threatening staff with imprisonments. So this is just an example of how Israel is accelerating its illegal violations against the Palestinian people, and this is the specific examples from last cycle, whereby 10 recommendations were accepted, and not only were they not implemented, but this is an example of systematic attacks against civil society organization. Another example, actually, from the recommendations from last year, there were also many recommendations that Israel accepted, not from last year, sorry, from last cycle. Many recommendations it accepted on the excessive use of force policy against Palestinians. And not only we have seen non-compliance and non-implementation, but also an increase in killings and excessive use of force. So I will just give some examples, numbers from recent attacks against civilians and protesters in Palestine. For example, last May, there has been a unity uprising in Palestine that started after Palestinians in Jerusalem neighborhood Sheikh Jarrah were under threat of being displaced from their homes. And protests sparked across Palestine, and what Israel has done at that time last year is that it instituted a policy of excessive use of force against protesters, and it also launched a military offensive on the Gaza Strip. So in just 1 month, in May 2021, it killed 276 Palestinians during demonstrations in the West Bank and also inside the Green Line, and during the offensive on the Gaza Strip. This is just also to give an example of how Israel accelerates and increases its violation against the Palestinian people. Other recommendations from the last cycle that were not implemented, not noted, not accepted by Israel include recommendations regarding ending the Israeli occupation, ending the settlement enterprise, the settlement expansion, stopping the demolition policy, also ending the annexation wall, stopping the exploitation of Palestinian natural resources, the confiscation, stopping the confiscation of and appropriation of land, ending the illegal blockade on the Gaza Strip, also ending the measures and policies in Jerusalem that alter the character of the city of Jerusalem, and many other recommendations that were not taken into consideration, were not accepted by Israel. Of course, the developments since then, that there has been an expansion of the settlement enterprise, the blockade on the Gaza Strip continues, and all this takes place within the larger regime of apartheid and settler colonialism. Now, a critique actually of missing recommendations from the last 3 cycles, a missing or weak language in the recommendation is that whenever addressing the self-determination of the Palestinian people in the UPR process, the language is leaning towards state building and a 2-state solution rather than calling for ending the colonial regime, calling for ending the illegal occupation, and calling for the return of millions of Palestinian refugees to their homes. And these are core prerequisites for the fulfillment of the Palestinian people to realize basically the right to self-determination. So these are some of the things that could be developed in the next cycles, recommendations that could be developed basically around self-determination and how to implement the self-determination of the Palestinian people, rather than focusing on calling for a 2-state solution, calling on structural changes, including the right of return of Palestinian refugees. Now, also, if we want to also look at the process in general, the UPR, given its, as we said, that it has non-confrontational approach, if we look at the Israeli regime and the nature of the Israeli regime, we should acknowledge that we have 3 overarching frameworks of the Israeli violations against the Palestinian people, that these human rights violations happening on a daily basis, they are not isolated acts. They are part of, first of all, a settler colonial regime that has been going on for a century now against the Palestinian people. This regime of settler colonialism basically wants to replace the Palestinian people, the indigenous people, with a settler population. We are talking also about an apartheid regime that has been operating for above 70 years now, also against the Palestinian people as a whole. So we're not only talking about the occupied Palestinian territory, but also Palestinians who are citizens of the state of Israel, and Palestinians who are refugees and exiles. And this regime of apartheid is basically based on the fragmentation of the Palestinian people and institutionalized discriminatory laws and policies, and also institutionalized policy of suppression of resistance. And a third layer of this regime is the illegal occupation, that we also, we're talking about a systematic denial of the Palestinian people to self-determination. We're talking about facts on the grounds, and an indefinite, actually, and not prolonged, indefinite occupation. We have no signs that Israel wants to end its occupation in the occupied Palestinian territory. On the other hand, it is expanding the settlement enterprise and systematically denying the Palestinian people to exercise their right to self-determination. So given all these overarching frameworks and the everyday human rights violation, when we look at the human rights, the UPR process, is non-confronting Israel a good approach? Maybe this is a question that we also should ask ourselves, and whether we should engage with the UPR process as Palestinian civil society and as supporters and friends of Palestine. I think this is an academic question, but I think we should not overlook the limitations of this process, the UPR. So we have to first of all develop the recommendations that have been recommended for the past 3 cycles. I said one particular example of how this can be developed, focusing more on the language around self-determination, ending the colonial nature of the Israeli occupation, focusing on the return of refugees, Palestinian refugees, as a core recommendation. But also, even if we want to develop these recommendations for the next cycle and for the next engagements during the UPR, we should also work simultaneously as Palestinians and as supporters of Palestine in other countermeasures and accountability measures and naming and shaming measures that the UPR process does not offer. So for example, we have our engagement for accountability at the International Criminal Court mechanism. We have our engagement as Palestinian people with the Commission of Inquiry as also a mechanism for accountability and truth acknowledgement. For countermeasures, we should note that given the systematic denial of the Palestinian people to self-determination, as well as the apartheid regime, that these 2 illegal actions and violations entail obligation on all states, so the international community, to basically cooperate to bring an end the illegal situation through countermeasures. And this is when we talk about sanctions. This is when we talk about stopping military trade with Israel, that the international community is not fulfilling this role, this obligation. Countermeasures could also include stopping the trade with the illegal settlement enterprise and importing goods from settlements. These are some examples. Also, the Palestinian people are constantly doing the naming and shaming approach with the special procedures, with the Human Rights Council, with treaty bodies, and so on and so forth. I think for the next session, for the next cycle for Israel, what could be basically focused on by civil society and Israel is stronger recommendations that would address the root causes of the Israeli occupation, but also focusing on concrete and concise measures regarding the recommendations that has been so far not implemented regarding ending the occupation and ending the settlement enterprise. States should have common, strong, concise recommendations on ending the occupation, because this is one of the things that all states actually agree on, that the Israeli occupation should end in the occupied Palestinian territory. So their recommendations should reflect this with strong, as I said, language and concise recommendations. On the other hand, civil society could offer stronger recommendations in terms of the right of the return of Palestinian refugees, in terms of the decolonization process in Palestine, I think that's it for my part. I'm happy to answer any questions at the end of the panel. Thank you.
I thank you very much, Hazel, for remembering us the dire situation of the Palestinian people is living, and also the difficulty, in fact, to have concrete recommendations in the UPR process, and of course, difficulty to have Israel to comply with international law and implement the recommendations. And of course, we stand firm with you against this aggressive policy of Israel against NGOs. Thank you very much. And now I will give the floor to Mr. Claude Adrien Zoller, President of the Geneva for Human Rights, graduated in Law and International Relations. Claude Adrien Zoller is a long-running and well-experienced human rights defender. He created the Ecumenical Research Exchange Center in 1974, focusing on studies for the anti-apartheid campaigns in Europe. He then got involved with Pax Christi, along with the World Council of Churches and several Catholic organizations, before creating the International Service for Human Rights in 1984. In 2003, he created Geneva for Human Rights, an NGO dedicated to training, study, and protection in the field of human rights. Adrien, you have the floor.
Thank you very much, ladies and gentlemen. I'm very glad to be with you this afternoon. To come back a little bit to my original commitment in '74, when I was in Rotterdam in this ecumenical center, my first task had been to help the delegation of the SWAPO with Sam Nujoma, and so going back to another debate on decolonization is for me very, very important. I have prepared a note, and I will not read out the note. It would take a lot of time, but I will first summarize the first 2 pages, and then the organizers could circulate my paper, which has to be improved, I see, which it has too many typing mistakes. The first, I think that in such a meeting, it is critical to highlight the beginning in the UN, the UN Charter. And as you know, we always remember people that the UN Charter has also objectives regarding human rights. And often we forget to mention that the Charter had also 2 different chapters. The chapter 11, and it is a declaration regarding non-self-governing territories, and the chapter 12, establishing an international trusteeship system. I don't enter into the details, but I think that it is very important to know that at the beginning of the establishment, the setting up of the system, this was already a priority for the UN. A priority which was really translated into the realities with the UN Declaration of December 1960, which is called Declaration on the Granting of Independence to Colonial Countries and People. This is the famous 1514 Declaration. The year after, by the way, the General Assembly created a special committee to implement this declaration. And as I've been involved over the last 40 years in the support and sometimes also the creation of procedures inside the UN system, I note that the countries of the South who obtained the independence and joined the United Nations, changed the system. These were the first countries who gave the impulse to the creation of mechanisms, to the creation of a response of the world community. It was not the Western states. India started in 1952 and raised the issue of South Africa. And this led to several procedures on South Africa and to a convention. The Arab states have raised the issue of the occupied territories in Palestine. And many states of the South of the non-aligned movement at that time have raised the issue of Chile, which obtained a special rapporteur in 1975. We had three situations, three exceptions to a rule which everyone agreed at the beginning, which was the rule of non-interference and state sovereignty. And you know, as you are working on the West Sahara, you know that the UN has made a lot of progress in the field of decolonization as well. I have here the note, but I am trying to summarize what I'm saying. At the beginning, according to the UN publications, almost 2/3 of the humanity were not part of the UN system. Dozens of states entered in the UN, and this majority changed the view, the vision, and the basic elements, what we call the standards for the human rights system, evolved as well. So this is where we are. Now, we have, in the case of West Sahara, we have a different system. First, I would like to make 3 remarks on the political level, public international law, and then at the level of the human rights abuses and how to raise it. Western Sahara has been one of the last territory which was dependent on colonial power. When the colonial power officially informed the UN Secretary General, and I quote, "The Spanish government as of today definitively terminates its presence in the territory of Sahara." This is of February 76. Immediately, Morocco launched its offensive and the Green March and invaded the territory, occupied the territories of part of the territories, and entered in a bloody conflict with the Liberation Organization, which was present at that moment and active, and it was the Frente Polisario. So at the political level, now the first negotiation led to some settlement proposals, which were accepted by both parties, the Frente Polisario and Morocco. The Security Council, on this basis, created a UN mission, the MINURSO. MINURSO was created at the beginning of I don't find the name, the date, 91. I continue to try to summarize these notes. Since then, the MINURSO has been extended regularly. The representative of the Secretary General was also involved in negotiations. Negotiations continued then, but basically with no other evolution than Morocco trying to obtain a fait accompli. The fait accompli is the fact that even at this moment, Morocco seems to refuse even the original consensus, namely to have a referendum. So at political level, there is a situation of a strong opposition of one of the two parties in this negotiation process inside the UN. In public international law, there is no doubt that Morocco is and remains the occupying power. And it has been already mentioned this afternoon that independent judges and lawyers who are less influenced by politics have taken recent decisions in international courts reiterating that Western Sahara does not belong to Morocco, which has major implications, obviously, for trade and commercial relations of those countries who try to take advantage of the situation. Now, concerning the human rights violations in the territory, as occupying power, Morocco has to respect both human rights and humanitarian law. Full stop. There should be no discussion about it. This is the position of all the systems. In the human rights systems, there are currently three main mechanisms. The first one is the Universal Periodic Review, on which you requested me also to present some reflections, but there are also the special procedures and the treaty bodies, which currently in the Human Rights Council are unfortunately neglected and even sometimes forgotten. The universal, so let's have a look briefly to the situation and what we could do. First, with the Universal Periodic Review. The situation in Western Sahara obviously has to be raised during the next session of the working group because it is the Universal Periodic Review of Morocco. This is an excellent process to raise, to get attention. However, the effect for the Sahrawi people will be very limited, as always, I would say. Though it is a mechanism to promote dialogue and to contribute to implementation, and I'm myself involved in many African countries where this mechanism is positive. The UPR is based upon the principles of equality between the states, not between the victims. And it is therefore not a real human rights procedure. Occupying powers in Palestine or in West Sahara are not going to change their policies through such a dialogue. We would make indeed this situation similar to the debate currently on Palestine. The special procedure, now maybe one more remark on the UPR, is that when we speak about recommendations in the field of UPR, it is only the recommendations as accepted sovereignly by the states, which limited the exercise. It is not a question of quantity, of number of recommendations accepted or rejected. Because first, before judging on this, one should have a look at some recommendations which are really sometimes abusive in terms of languages, in terms of misuse of the procedure. The special procedures, on the contrary, are more effective. Their mandates are universal and unfair trials, arbitrary detention, peaceful protest, attacks on human rights defenders. This is common in Western Sahara, and the occupying power has to stop this. We should really submit more cases on such cases occurring currently in West Sahara to raise more attention. And I know that the next speaker will speak more in detail about it, so I don't enter into more details. The last remark is that Morocco is also a party to Human Rights Convention, and which are monitored by treaty bodies, by committees of experts, as you know. And these committees receive also regular reports of the state party. Now, when one of these committees receives a report of Morocco, the committees should have received also more regularly some shadow reports and some communications on concrete cases, because some treaty bodies, such as the CRB, have also specific procedures to intervene in between their meetings. Regarding the case of West Sahara, therefore, no, I do not want to discourage people to work through the Universal Periodic Review. I think that the other two main procedures should be used more regularly. And at least, to my knowledge, maybe I am not aware of all what has been done by all the support groups and by the countries supporting Western Sahara. But there is one problem in the Human Rights Council, and it is a major weakness, namely the lack of one specific item on the agenda of the Council to discuss self-determination. In the former Commission on Human Rights, resolutions, for instance, on Timor-Leste were adopted under the agenda item, self-determination. The lack of such an item is a major problem for those who would like to raise the issue of self-determination in Western Sahara in the human rights context, and not only in the diplomatic and political context. I myself, it is now 15 years ago, I would have preferred personally that the item 7 of the agenda of the Council would have included all the issues of foreign occupation and self-determination, and not only one situation. I thank you very much.
I thank you, Adrien Claude, for your very inspiring presentations. And indeed, it was a big discussion 15 years ago when the when the council was created in the one-year negotiation for the establishment of the agenda. Morocco was really instrumental in avoiding to have this standing point on self-determination as it was with the old commission. So thank you very much, Adrien. And now we will move to Professor Mats Andenes, who is a lawyer in Norway and a barrister in England and Wales. He was director of the British Institute of International and Comparative Law in London and director of the Center of European Law at King's College at the University of London. He also chaired the Norwegian Association of European Law and the Association of Human Rights Institutes. Since 2008, Professor Andenes also chair in the Faculty of Law at the University of Oslo. He has also taught in different universities in Paris, Rome, Brussels, London, Hong Kong. And he has published dozens of articles in several law reviews and about 20 books on different subjects. Between 2009 and 2015, Professor Andenes was a member and even chairing the UN Working Group on Arbitrary Detention. Professor Andenes, you have the floor.
Thank you very much. That was very kind of you, Gianfranco. And it is, of course, a great privilege to be on the panel, and also a great honor to come just after Adrien Claude Soler with his very pertinent presentation. My perspective is a rather limited one. So I will say something about the UPR, the Universal Periodic Review, but it really is to provide a background for how can one make sure that the how can one make sure, somebody's coming into my room, I'm sorry. So how can one make sure that the different decisions, the different opinions which have come from the special procedures are included in the UPR? Because the UPR is a pretty autonomous process. So what happens is that the secretariat, and there's a special UPR secretariat, will prepare materials. And then the different countries in the UPR, Human Rights Council members, member states, will then provide questions and information. So then, if you were thinking about the work which has gone on for all these years with the treaty bodies, torture committee, with the special human rights committee, a whole range of bodies, and then with the special procedures, with opinions after opinions, urgent appeals after urgent appeals. And as you said, I chaired this working group for arbitrary detention for some years. And of course, we had to rule on a number of cases. And the working group still is the only of these special procedures which hear individual complaints and rules on them. And what is the force of those rulings? The force of that ruling, or those rulings, is that they come from the body that the Human Rights Council has appointed to deal with arbitrary detention. And they've chosen experts, 5 experts from all over the world. Is this legally binding? That causes lots of ructions, you know, is it legally binding or not? Well, there are these experts, and I think you should say that you have to have a lot of expertise on arbitrary detention in international law if you, as a national judge or as a national government or anybody else, want to say the working group, although they've found that there's a violation of Article 9 of the, for instance, on arbitrary detention, or in that context, that there has been violations of the torture prohibition. In spite of them finding that, I have, or my body or my government has another view, and we don't accept what this body, what the working group has found. Now, that is a very difficult case, but how do you use these opinions? And of course, if you were pleading in the Moroccan court of appeal or Supreme Court, they will have all kinds of arguments to say that they should not abide by it. And of course, if one wants to be a bit self-critical for a moment, you know, coming from Northern Europe, the working group held that Julian Assange was in arbitrary detention. And the Swedish government and the UK government, the two governments in that case, they neglected their opinion, and they said, oh, this is a body which we can't follow. And they even tried to smear the experts in a way which was inappropriate. But then next round, the UK accepts the working group's opinions. So how do you weaponize this tension? You know, it's not binding. It's not easy to go to another mechanism and say enforce it. Well, the UPR is such a mechanism. It's a mechanism in the sense that you could use these opinions from the working group on arbitrary detention, all these other special rapporteurs, torture reporter, there's a whole host of them who then have ruled against Morocco, including with urgent appeals. This or that person is subject to prison conditions or torture or threat of for his or her health. So do something. And then again, the treaty bodies, which are extremely helpful here and of course very authoritative. Now, back to my starting point. You have this range of opinions which have come out of this process. And then they won't get into it at all. They will, well, for instance, all the findings by the working group on arbitrary detention, and there's some 10 really important decisions, sifting through the law, sifting through the facts, and having very specific rulings. I myself, when I was chair rapporteur, or president rapporteur of that working group, I walked around in these Moroccan prisons and met Sahrawi prisoners, and I went to Laayoune, and yeah, it was not a pleasant time, I can tell you. And meeting the people in prison was and just to cry out. But we collected material. We collected material and evidence, and we used it to come with clear conclusions on the arbitrariness and violation of international law in detaining. After all this work, a large number of individuals. So then, how does one get this into the UPR process? Of course, I can't get it into the UPR process, and you, unless you happen to be an ambassador from one.
Micro.
So then, if I am not an ambassador, I can't get any of this in. But that's where, for instance, the groupe de soutien de Genève pour le Sahara Occidental, you know, the countries there, they're immensely important. So then a good civil society initiative now would be to make all the countries which are represented in the Human Rights Council and takes part in the UPR process, and really, whichever country it is which is on the side of the Sahrawi people, give them lists, provide them information, tell them, here are the decisions we want you to bring up. And then it will, if that country insists, there's nobody who could stop them, that material will go into the work of the UPR process. And again, it won't happen without anybody doing it. You really have to push ahead and present those lists. And you know, diplomats are like everybody else, short of time. So everything one can do, giving the exact form one wants it to go into the UPR process at exactly the right time. And if one is too late, hurry up and get it in now, you know. I think could be immeasurably helpful. And I say this because I really worked in a previous UPR round with other countries, not Morocco, because it wasn't, it didn't fit, the periods didn't fit, so I could put any of this in. And it was extremely difficult for me to do. And that's when I was an office holder, a special mandate holder. But the delegations, the diplomatic missions of the countries which now are members of the Human Rights Council, they can get it in. And I think that will change the UPR process when it comes to Morocco. Because one thing is to say at a very general level, here we've got the international law, here we have got a series of violations. You know, these cases with a hyperlink to the facts, they are horrid cases. It's extremely difficult to defend yourself against it. And we must remember that Morocco, in my experience, is among the most effective countries in terms of exercising their diplomatic skills. They are extremely skilled, extremely efficient, and they do a very, very good job. And also, they have friends. And you remember the war on terror? It's still there. They're a friend of many countries. They have given services to many countries, which they want something in return from, and they will get it. And also, of course, it's in the neighborhood of Europe, and Europe wants to include. And right now, of course, President Macron is talking about the political union. That does not directly include Morocco. It does actually include Turkey, but it is to some extent pushed ahead or triggered by all the issues, or at least be given higher priority due to the Ukraine situation. And but it does mean altogether, you know, Morocco is on the outskirts. And then I have a paper which Gianfranco can distribute if he wants to, you know, because I have gone through a number of legal points there. And I thought that the important issue for us all is, of course, that the law is to, well, this is about international politics, international relations, and law is just a factor. And one problem for us is that when it comes to human rights and when it comes to self-determination, these are fundamental legal rules which should not be pushed aside by political considerations, but they are. And that's why it is so important to use the legal mechanisms which are remaining as autonomous, you know, not being neutralized by the political expediency here. And in the paper I've given to Gianfranco, I put in that, you know, the and Tone, whom I work with, that of course this applies not only to the UN mechanisms, that you have these special procedures and treaty bodies that work. You know that we have the Court of Justice, very important decision from the 1990s, which is the basic the Security Council resolution from the early from the 1970s, which is the basic decision. When it comes to court decision, we actually don't have that much to look at. But what we have, in addition to what comes from these special procedures at the UN level, we have the decisions by the European Court of Justice. So the International Court of Justice is of help, of course, and the European Court of Justice is of help. And now the litigation which is going on in front of the European courts, the European Court of Justice, are important because they make the court looks at obligations under international law and in the European Union law by the European Union. What are their obligations? So that the very good litigators who challenge that say, here you are in breach of your international obligations and EU law, European Union law. And again, that is something to bring in before the UPR process, so that it is very unnatural, I would have thought, and it'll take a bit of convincing to get, for instance, the South African ambassador or the person who meets for them in the UPR process to say, well, make a reference to the European Court of Justice. But it is extremely helpful because it does, again, give increased weight to the UPR process. So it's just not countries which have some discussions, and you know the format of the UPR process is that you then maintain your criticism as a country against another country. That country responds, and then the country may or may not take note, or may not want to do anything with it. And when it comes to Western Sahara, likelihood of Morocco admitting to anything is very, very weak. But if a country makes reference to the legal mechanisms, including the recent litigation going on in the European Court of Justice, that would strengthen those objections, because it's not something a country can explain away. And I would say that is something which is worthwhile focusing on. I have a couple of small additional points. The paper is much better structured, in the sense that in the main part it goes through the opinions by the UN Working Group on Arbitrary Detention, and there's 22 cases, 9 opinions. There's no other country which have more cases. and in the decisions rendered, there's a systematic pattern of arbitrary arrest of activists and a modus operandi of torture and arbitrary imprisonment based on torture signed confessions. And then you have all these other UN special rapporteurs, as I mentioned, and a very important initiative has come from the Special Rapporteur on Human Rights Defenders, Mary Lolo, who then, alongside the Special Rapporteur on Extrajudicial Killings, the Special Rapporteur on Freedom of Expression, the Special Rapporteur on Freedom of Association, the Special Rapporteur on Torture, and the Working Group on Discrimination Against Women, went and in different ways have looked at the ongoing house arrest of Sultana and Luara Kaya and the sexual assault in 2021. Now, it's extremely powerful. That communication of 10th of June last year is extremely powerful, and my point is that the UPR will offer an occasion to bring that into the Human Rights Council, into the discussion, and would force Morocco to try to reply to it, which it cannot do. And this is, of course, you could say very practical, and perhaps as several you have said, these procedures will not change the situation radically or quickly, but using the UPR to make these different mechanisms hang together and to weaponize them or to make them more powerful, give them a stronger force. I think that is the major contribution that this UPR process can give, and it is for civil society to work through these different members of the Human Rights Council participating in the UPR process. And all of them can, all of them can send in a note with and make these references to all of these opinions from the special procedures and the treaty bodies. Is that all right, Gianfranco, from me? And then, if you want the paper with the facts and in a more Cartesian way, you could distribute if you like to.
Of course, and thank you very much, Mats, for sharing your experience, your analysis, and your advices, of course. And also for your continuing support for the Sahrawi people. And yes, indeed, we used to publish the compilation of all presentations in the webinar conference or side event in the Palais. So, of course, it will be published. Thank you very much.
Thank you.
And now, last but not least, I will give the floor to His Excellency Mr. Ubi Bushraya, Minister for Europe of the Sahrawi Arab Democratic Republic. Ubi, you have the floor.
Okay, good afternoon, everybody. Thank you, Gianfranco, for the opportunity. And through you, I want to extend my thanks to the Group of Geneva, also to Ambassador Nkosi, for chairing the group of ambassadors, and that jointly with you, you are doing a great job in lobbying and defending the rights of the people of Western Sahara, and also extend my thanks to the speakers in this panel that have succeeded in providing us with the elements, necessary elements, first of all, to understand the complexity of the system, and then also, of course, to come up with the proposals and the solutions to overcome whatever impediments in this regard. It is indeed a timely topic to organize this webinar touching on this very crucial issue around the fourth periodic review of the Kingdom of Morocco within the 41st session of the working group coming up in November 22. the exercise of the UPR in itself is important because, of course, of many reasons, but especially the direct link between this exercise and the accountability or the lack of accountability of Morocco on the ongoing violations of human rights that are committed by the occupying power in Western Sahara at many levels. The parallels between the struggles of the people in Western Sahara and Palestine, and also the impunity that the two occupying states are enjoying within the international system, are almost identical. So I want to salute the rationale and the concept behind the bringing of the two cases together that are the most explicit cases on the deficiency, but also the lack of adequate attention from the international system at large, but most especially the UN Human Rights Council on this regard. So the impunity is almost total and at many levels. At the political level, the refusal of Morocco and of course of Israel to abide by the UN resolutions, especially on the right of self-determination, and the denial to lift the military occupation on the two respective territories. You would recall, all of you, that Morocco tried to impose its military occupation on the Sahrawis between 1975 and 1991, causing all the disaster and the suffering, both at the Sahrawi level but also at the regional level. And then they had to, because of the resistance of the Sahrawis, they had to agree on the referendum. But since 2 years, 2020, we are unfortunately back to square zero, with greater dangers where the countries in the region are more exposed in terms of the stability and the security. And now recently, as you notice, the expansionism, the Moroccan expansionism, is back and alive, with all the impunity, and the Security Council is silent on the Moroccan lack of cooperation, but also on the Moroccan intransigence and the disposal to bring the region to all sorts of dangers that everybody is following now. We think it is high time, for the sake of the future of all peoples in the region, that this impunity be ended, and that Morocco and of course Israel become, both of them, accountable on the violations of the human rights, but also they become accountable in front of the international system. The second level is on the natural resources, and I'm not touching a lot on the parallels because they are evident, where the two occupying powers, Morocco in this case, is still violating the rulings of the UN, but also of the European Court of Justice on the plundering of the natural resources of the territory in Western Sahara, with all impunity, enjoying all possibilities to finance its own occupation and also encourage the colonial settlements in the territory. And the same case is going on in Palestine, with the continuing plundering of the natural resources of the Palestinian colonies against the international rulings in this regard. And the third level, of course, is on the human rights, and which is the topic that we are dealing with principally today, where Morocco and of course Israel, both of them are book cases of being able to commit all sorts of atrocities against the colonized people, the defenseless and civilian populations with no fear
Apparently, there is a small technical problem.
Yes, there is small.
Yeah, I think because Minister Bouchraria is actually in the refugee camps in the desert, and I think he's having some technical problem with the connection. So I hope that you will be able to come back to us. Omeima, tu peux lui demander de se reconnecter?
Oui, je viens de le demander.
Très bien.
He is not receiving my message, so probably one moment, please.
Yeah.
Yes, he's inside. He's with us. He's with us.
I don't see him.
Yes.
Oui. Obi, tu peux reprendre. On t'avait perdu. Peut-être tu reviens un paragraphe en arrière. Tu mets le micro.
Speaking about the third level of those of this impunity is with regard to the human rights, where Morocco and Israel are both of them a bookcase on being able to commit all sorts of atrocities against the Sahrawis and Palestinians with no fear at all to any sort of reaction from the international community, especially from the UN Human Rights Council. And I was saying that Abba Haysen, who is the president of the Sahrawi Commission of Human Rights, spoke lengthily and in details with all sorts of violations going on in Western Sahara, and I'm not going to repeat them. The Moroccan UPR, the coming Moroccan UPR, and the lack of pressure on the Kingdom of Morocco is unfortunately the illustration of the continuing of the fact that we are still very far from securing an acceptable degree, the minimum of conditions to install a sort of accountability on Morocco in this regard. Of course, great efforts and good results have been achieved within the UN Committee Against Torture, special procedures, human rights international organizations, civil society reports, etc., etc. But still there is a long way to walk before this great effort gets a real impact on the UN Human Rights Council. And I think the reason is because of this continuing clash within the agenda of the individual states between their geopolitical choices and the universal human rights values. And I do believe that this is an opportunity to launch an appeal on behalf of the Sahrawi people, and I would imagine also on behalf of the Palestinian people, that governments individually and collectively should depolitize the human rights and instead universalize them. Between the inaction and sometimes even the wrong actions at the level of the UN Security Council and the UN Human Rights Council, there is a sort of vicious circle that has been created, where the absence with the UN Security Council of legal, just, and firm push to the political settlements in Western Sahara and Palestine is contributing to deepen the suffering and the violations of human rights and the abuses in the two territories. But at the same time, also the lack of serious and sustained and committed action to address the human rights violations in Western Sahara and Palestine within the Human Rights Council is also feeding the political tension and averting any possibilities for a peaceful settlement in the two territories. A comprehensive, inclusive, and global approach on the basis of the international law on one side, and also a universal human rights norms on the other side, is indeed a necessity now to address or to find the solution for this crisis. Impunity may strengthen the choices of some individual countries, but it is contributing to weaken the collective choices of the international system. Once again, I want to congratulate you, Gianfranco. I want to congratulate the speakers on the panel who I think have succeeded largely in combining between the technicalities, but also the vision on how to deal with this enormous challenge that is that we are facing, which is bringing Morocco within the UPR exercise, but also beyond, to respond to the crimes that is continuously committing in Western Sahara. So I thank you, and I'm sorry for the technical problems that interrupted the connection in 2 or 3 times.
I thank you very much, Minister. And now we have a few minutes left. So I don't know if anyone wants to raise a question or make a comment. Please click at the bottom of the screen, the small hand, and so that I can see if anyone wants to have the floor. If this is not the case, I will just thanks again the panelists and everybody who has followed this webinar conference. Thank you very much for your interest. And of course, as Professor Dennis said, we are providing the UN member states with many reports, information, also about the mechanism, the UN mechanism decision. And we really hope that in November we will have some more concrete recommendations, including from European Union member states. So thank you very much to all of you, and see you soon, maybe here in Geneva or through Zoom. Thank you very much.